You just got blocked on Facebook, Instagram, or TikTok. Someone silenced you for expressing your view on social media. Or maybe you were just stating some facts, or maybe you were being a little bit snarky. Does this violate the First Amendment to the U.S. Constitution?
Social media blocks, post deletions, group removals.
Freedom of speech under the First Amendment.
Research shows how common it is for users to silence another user on social media. Can this ever violate free speech rights under the U.S. Constitution?
A narrow set of circumstances exists where this is possible, but this is the exception. In most cases, the answer is definitely no. The vast majority of social media blocks, post deletions, or group removals occur between ordinary citizens engaging in their private lives on social media. So why doesn't the First Amendment apply in this context? The short answer is that the Free Speech Clause of the U.S. Constitution applies only to restrict state action. This means that your fundamental right to freedom of speech is effectuated through limits placed only on government power. The Supreme Court has firmly established the state action doctrine in many cases over the years. It has repeatedly held that the state action doctrine prohibits only government action that infringes speech, not private action that does so. And state action covers any government entity or person acting with power derived from the state. So, for example, state action includes a law or resolution passed by a legislature. It also includes executive actions by public officials or agencies. And of course, it includes court orders or administrative orders or agency regulations. So, state action can apply at all levels of government. Federal and state governments have legislatures, executive branches, and courts as well. State action can also apply in the case of local governments, such as a city, a town, or a village, or even a small state-run park. The requirement for state action derives from the language of the First Amendment itself and from the language of the 14th Amendment. The 14th Amendment is the one, by the way, that incorporates the First Amendment and applies it to the states. Even the federal statute that is used to enforce free speech rights tracks this state action requirement. Finding state action and a state actor isn't complicated in most free speech cases. For example, when you have a prison official, police officer, or the FBI doing something, it isn't hard to find state action.
And finding a problem with state action or a lack of state action in many cases also isn't hard. Assume a patron is told to stop yelling political mantras in a local bar. Assume a parent tells a child to stop talking about some subject. Is there state action in these cases? Not at all.
The Free Speech Clause of the U.S. Constitution does not apply to ordinary citizens or private entities and their interactions and behaviors, and this includes activity on social media that silences speech. Why? Because there's no state action. Okay, so that's the general rule. But what about the exception I mentioned earlier? Can there be state action on social media that silences free speech? I said earlier that there can be in a narrow set of circumstances. So this leads to another question. Can state actors get on social media? Intuitively, you probably know the answer is yes. So then it seems at least possible that state action and a free speech violation by that state action can occur on social media. And this is where a recent Supreme Court case comes in. The case was titled Linkey versus Freed. Here are the basic facts of that case.
In Linkey versus Freed, a city manager had a Facebook page. On that page, a city resident had made snarky, critical comments about the city's policy. The city manager then deleted the posts and ended up blocking the resident, silencing him for his critical views.
It was just my personal Facebook account. I believe he was actually incarcerated at the time. So based on that, not what he posted, on what he said, I blocked him.
Was this state action causing a First Amendment violation? Well, the answer depends. We now have a state actor on social media doing the blocking and deleting, doing the silencing of somebody else for their views. But just because a person decides to work for the government doesn't mean that that person loses all of his or her constitutional rights. Can't a city official get on social media and express a viewpoint too? Assume a city official gets on social media and discusses family life or a tennis match or some other aspect of personal life. Then somebody criticizes or mocks that and they block them. Well, we have a state actor, but this activity has nothing to do with the state. So clearly we need more than just a state actor when there's silencing of speech on social media. State actors can clearly take off the government hat and put on the personal hat. And this is exactly what the Supreme Court was grappling with in Linkey versus Free. And here is a further problem. In Linkey, the Supreme Court said that the city manager had mixed official and personal business on his Facebook page. So this complicates the analysis even more. The Supreme Court explained that this can make it difficult to draw the line between official conduct and personal conduct. If the city manager mixes official and personal business on his Facebook page, then which hat is he wearing? The personal hat or the government hat? And which hat was the city manager wearing when he silenced the city resident who was critical of his views? So the Supreme Court focused on how to figure out when an official is acting in a personal capacity, which is not state action, or an official capacity, which is state action, when that official acts on social media. So the court developed a two-part test to determine when a state actor's social media activity constitutes state action.
And here's that test. The official had to have actual authority to speak on the state's behalf, and the official purported to exercise that authority when engaging in social media activity.
The first part of that test means that an official's social media activity cannot just look official to constitute state action. It must actually be official. The official must have engaged in social media activity and communications with actual authority to do so. And this actual authority can come from statutes, regulations, and even city ordinances. And it can arise even when there is no law on the subject if there was a custom or usage of the official having actual authority to communicate on a particular subject. Actual authority can come from custom or usage when an official's power to handle communications on a subject becomes permanent and well settled from prior officials in that same position. Okay, so there's one other way to establish that a state actor has actual authority to engage in social media activity or other communications. Sometimes the very nature of an official's position establishes broad authority over a given subject. This broad authority over a subject includes authority to make official communications about that subject. In other words, the scope of employment can be so broad that it includes the authority to communicate about subjects within that scope, even if state law and custom doesn't expressly create that actual authority. And some of you may be wondering how actual authority to engage in social media activity or some other communication includes the authority to violate somebody's free speech rights. That's a great question. If an official has actual authority on a particular subject to engage in social media activity or other communications, but then misuses that authority, the Supreme Court has clearly held that that still constitutes state action. So now let's turn to the second part of that two-part state action test in the context of social media activity. The second part of that test was that the official must have purported to exercise the state authority when engaging on social media. What does that mean? That means that officials must appear and behave as if they are acting in an official capacity, not a personal capacity, on social media. To better understand this second part of the two-part state action test in the context of social media use, it helps to consider two examples the court gave that can help officials prevent their social media activity from looking like state action. Those two examples were disclaimers and labels. Disclaimers on a social account might say something like, quote, "The views on this page or account are personal and are strictly my own. The views are not the opinions or views of the public entity or state office for whom that person works," end quote. And for labels, the account needs to describe prominently, probably in several places, that the account is a personal account only. This way, there's no confusion about whether the person who runs the account has the government hat on or the personal hat. It doesn't look official when you say the account is a personal account and then act as though the account is personal. The most conservative approach would be to never mix personal and official use in your social media activity. This means use a public account strictly for official purposes and don't ever silence somebody for expressing their view on that public account. And use your private account strictly for personal purposes and don't mix official business on that private account. And of course, include that personal label on the personal account. And a disclaimer can't hurt either. And don't blur the lines on that private account by doing anything official or anything that looks official on that account. There's one more nuance here to note. A public official cannot get around the First Amendment in a sneaky way by using disclaimers and labels solely to avoid liability for official acts that violate other people's First Amendment rights under the test announced in Linke. This might be the case if an official created a page with perfect disclaimers and personal labels. The account would be labeled as personal, and it would have a disclaimer stating the views expressed on that page were strictly personal and do not reflect the views of that official's office or of the larger government entity to which the office relates. But then the official posts about a subject with actual authority and purports to act in an official capacity in doing so, and then blocks people with critical viewpoints. That would likely be a problem under the First Amendment. Okay, let's sum it up here. Can a block or a post deletion on social media violate your First Amendment rights under the U.S. Constitution? Only in rare cases and under a narrow set of circumstances can it do so.
The official had to have actual authority to speak on the state's behalf, and the official purported to exercise that authority when engaging in social media activity.
And then the state actor silences you for your views. But virtually all other blocks and post deletions on social media have nothing to do with the First Amendment. And lastly, please remember that this is not legal advice, and I cannot account for your unknown fact-specific circumstances or those of many other viewers in various jurisdictions or nations with differing laws. Thank you for watching.